Welcome to BCS, the Chartered Institute for IT. My name is Brian Runciman. We have an excellent panel today to discuss the Schrems II update. There's lots of things going on. Facebook recently have said that they feel like they're being a little bit picked on. That was in the newspaper only yesterday. We do acknowledge the irony of doing this on Zoom, so please try and put that to the back of your minds while we have our conversation today. In terms of context, my panel have already said to me today that they hear a lot of strange remarks. This doesn't apply to me. I don't do movement of data. Or after Brexit, this stuff just won't be relevant anymore. Well, we're going to discuss those sorts of questions. Let me just introduce the panel for you. Say hello first of all to Chiara Rustici. Chiara is properly independent, and she's the head of the BCS specialist legal specialist group. So hello, Chiara. We also have with us Dr. Kuan Hon. Dr. Kuan Hon is going to do a presentation for us in a minute. She's an author, and she's also the director of the Privacy, Security and Information Law team at Fieldfisher. And also we have with us Adam Leon Smith. Adam is Chief Technology Officer, Data Protection Officer at Dragonfly, and the chair of the BCS Software Testing Group. So we've got people that know what they're talking about and people that are very aware of BCS as an organization, so that's all good. We would encourage you, if you'd like to ask questions that you'll see at the bottom of your screens here, and I'm sure we're all familiar with Zoom by now, that you can put questions in the Q&A there. Things might come up that spark off and trigger questions. Some of them we will try and deal with today as best we can. Some of them we might not be able to, so just due warning there. But we will do our best with that. So without further ado, I'd like to introduce Kuan Hon. She's going to give us a little presentation to start with, just to give us some context. So over to you, Kuan. Thank you.
Unmute myself and share my screen. Okay, everybody see that all right?
Yep.
Great.
That's good.
So this is just an overview to set the scene for the panel discussion that follows for people who are not so familiar with this area. Now, GDPR, the General Data Protection Regulation, of course, regulates the processing of personal data by controllers and also by processors who are used by controllers to help them process personal data. But it does apply directly to processors, not just controllers. Processing is much wider than people think. It includes merely storing, transmitting, or accessing or viewing data, not just doing something with it. And the definition, the concept of personal data is, again, much broader than most people think it is. Almost everything is going to be personal data under the GDPR. So that's important to bear in mind. Just to mention briefly, I didn't put the link in these slides, but there is a video called Lawyers Are From Mars, Techies Are From Venus, which does on YouTube, which does discuss this and other issues between lawyers and technologists and the definition of personal data. Now, transfer, of course, is the key concept we're talking about here. It is not defined in the GDPR, but it does include pull as well as push transfer. So if you're sending personal data outside the EEA, that's a transfer. You're sending it so that it's hosted outside the EEA, there's a transfer. But also, if you allow somebody who's outside the EEA remote access to view, not just take a copy of, but just view personal data that is stored physically in the EEA, that is a transfer. So that's a very broad concept again. And unfortunately, it's very much location centric, based on the physical location of personal data, rather than what I think it should be, as is mostly covered in my book, effective jurisdiction. Which country can make a controller or processor hand over personal data, regardless of where geographically it's stored? The ICO is moving more in the direction of effective jurisdiction, but that's not the general view across the EEA. So bear in mind, personal data is very broad and transfers very broad, and it includes not just, as I mentioned, remote access, but also remote access for support purposes, not just viewing data or doing something with it. Now, in cloud computing, the role of the cloud service provider does vary. Some cloud providers could be controllers, some can be processors. Much depends on the type of customer. So where it's a business customer, an enterprise customer of a cloud provider, then usually the cloud provider is a processor, but it can be a controller for some aspects, as witness the regulatory insistence recently in relation to Microsoft to say it's a controller of some things or some processing. Where the cloud provider has mainly consumer customers, then generally the cloud provider is going to be treated as a controller. And transfers can involve all sorts of personal data. It could involve account data. It could involve personal data uploaded by the cloud customer. It could involve backups. And again, access for maintenance and support reasons. That could all be transfers. So a recap on transfers and transfer mechanisms. Under the GDPR, transfers outside the European Economic Area to so-called third countries are banned, and similarly transfers to international organizations are banned unless one of three main conditions applies. The first is that the recipient country has been declared to have adequate protection under a Commission decision, and examples include Israel and Japan, and of course the now defunct Privacy Shield for transfers to the US. When the Commission decides whether a country provides adequate protection, it has to consider a certain list of factors to see if essentially, if there's essential equivalence that is given to the protection in that country. The second condition is appropriate safeguards. So SCC, standard contractual clauses, and binding corporate rules, BCRs, are examples of appropriate safeguards. And just to say a bit more about SCCs, because of course that's the main subject of the Schrems decision. These are standard contractual clauses in an approved format, which the Commission has decided will be acceptable. And there are two sets of SCCs for transfers between controllers to other controllers, C2C. There's one set available for controller to processor transfers, C2P. That was covered in the Schrems II decision. We don't have any approved clauses for transfers between processors and other processors or sub-processors yet. And the third condition or gateway is if one of a set list of derogations applies, like consent. But regulators take a quite strict approach to this and saying that if you want to use the derogation, it has to be a one-off or very rare, occasional. It can't be for repeated regular transfers. Now on to the Schrems II decision itself. As I'm sure most people know, that's a photo of Max Schrems, and he was responsible for putting an end to the EU-US Safe Harbour a few years ago, which is the predecessor to the Privacy Shield. And now, of course, recently, the Court of Justice of the EU has ruled that the Privacy Shield, which replaced Safe Harbour, is also no longer valid. It doesn't provide essentially equivalent protection for personal data. Now, standard contractual clauses, which were the main subject of this case, C2P, standard contractual clauses, I should say, they are kind of hanging on by a thread. The court said they are still valid for transfers, just about. But what do you have to do to use SCCs validly? Not as clearly put as it could be, verify the third country law's adequate protection by providing additional safeguards. Well, really what this means is a kind of risk assessment, and what I would like to call APA, or adequate protection assessment, because you're kind of looking at the adequate protection of personal data in the country in question. Of course, with SMEs, how on earth are SMEs going to look at the laws of every single country to which they might want to transfer personal data? It's a pretty much impossible task. So in practice, it is becoming not uncommon to just forget about looking at the laws, think instead about what additional safeguards can be provided if the laws might not be good enough. the European Data Protection Board, which is regulated, EU data protection regulators acting collectively, term this supplementary measures. So what safeguards or supplementary measures can you put in place just in case the SCCs are not enough? Might depend on the types of the recipient, the types of the data, the types of data subject. Could these be contractual, extra contract terms? Could they be technical, like encryption, or a mixture? Now, after the Schrems II decision, the European Commission is discussing Privacy Shield 3.0 with US authorities. We don't know what it's going to be called. We've had Safe Harbour, we've had Privacy Shield. So is it going to be Privacy Elastoplast, Privacy Bandage? Who knows? But we will find out in due course. But that's bound to take a while. The Commission is also going to produce updated and more comprehensive SCCs, the earliest being by the end of this year, they've said, which will hopefully be better than the existing SCCs from a Schrems II decision viewpoint. Now, in terms of data protection regulators, there is no grace period, and the court has said they have the power and indeed the duty to stop unlawful transfers. The European Data Protection Board has issued FAQs already about this decision. However, they have not yet issued guidance on what are these additional safeguards or supplementary measures that could be put in place to try and overcome SCCs not necessarily being sufficient in some cases. So they've set up working groups on these measures, and indeed NOYB, None of Your Business, which is Max Schrems' group, has actually issued a lot of complaints about a lot of companies on their transfers. So the EDPB has set up a group to look at that as well. The UK has said we're going to take a practical, pragmatic view to transfers. Germany, slightly different story. The Berlin Supervisory Authority has said, not ordered, but just said, actually, you should even bring the data back, which might be too late if US authorities have already got hold of it. Another authority has said encryption might be possible as a supplementary measure if the cloud customer control or the transferor controls the key. We also know that the Swiss Privacy Shield has effectively been invalidated as well in the aftermath of this, the EU-US Privacy Shield, even though technically it's actually a different system. Switzerland is not in the EU. Cloud providers that used to rely on Privacy Shield are scrambling to put in place SCCs or offer SCCs instead to their customers, because at least SCCs are still valid, even though we don't know what these supplementary measures are. They could be good enough. Now, I had to mention Ireland because there's a fantastic typo in this news report. The Irish Data Protection Commissioner had issued a preliminary decision, a draft decision to Facebook saying, we want you to suspend, or we will order you to suspend transfers. And Facebook has managed to get a court order to say, no, don't actually implement that decision yet until the court actually hears the whole thing. I've highlighted one paragraph where there is an amazing typo about daft finding, which I will not comment on whether that's deliberate or not, or how apt that is. So there's lots of practical implications for lots of organizations in the aftermath of Schrems II. What about, if you've been transferring based on Privacy Shield, what do? If you're an US organization receiving transfers based on Privacy Shield, what do? What about SCCs for transfers to the US? SCCs for transfers to other countries? What about controller to controller SCCs? Similar issues, even though it was controller to processor SCCs that were considered in that case. What about what about a processor to processor transfers? Processor to controller transfers? BCRs? One thing at least is that if you transfer to a country which has been declared adequate, then it's okay. unless and until the court says it's not, which will take a few years if anybody tries to challenge transfers to one of the countries in the list, for example. So we might have a bit of a whack-a-mole if you have Privacy Shield 3.0 and then that's declared inadequate, and then you've got 4.0 and that's declared inadequate, and so on, but who knows. And then, of course, there are other issues like direct transfers by consumers to non-EEA organizations. Number of organizations are considering localizing data or repatriating it. And of course, there is an issue about two-way transfers. Like the UK, after Brexit, the UK has said it's okay to transfer to the EEA, but then how do you get the data back to the UK? So quite a lot of issues, and a lot of people might be forgiven for feeling like this. But of course, there has to be a practical solution. Everybody's working on practical solutions. And I'm not going to go through this. This is just to highlight, and there's a link at the top to the results. Fieldfisher conducted a survey of what people are doing in relation to Schrems II and what do they think about what's happening. This is obviously a snapshot in time, but the results are quite interesting for those who want to go and have a look. So more links for more information. Again, that's all in the PDF for anybody who's interested. So thank you, and we can move on to the discussion now.
Thank you very much, Kuan. That was really interesting. We appreciate your work there. If anyone would like a copy of Kuan's presentation, please just drop me an email at BCS. I'm editor at bcs.org, and I will send that out to you. Can also say that I personally will be lobbying for Privacy Elastoplast. That's what I want to see as the name of the updated information. So can you stop sharing your screen?
Yeah, I'm trying to. I'm having some trouble getting the controls back, actually. So can you share me, perhaps? I'm not sure where they've gone. Okay. I did try to minimize at one point. Okay. That's very strange. I've lost everything but the picture. Here we go. Got it. Thank you.
We're back. Very good. So thank you for that. So let's move on to our discussion then. First of all, a little phrase that pops up all the time is due diligence. So we're just going to start off by discussing what does due diligence mean in this context, and we're going to just come over to Adam, please, to start with that one.
Thanks, Brian, and thanks, Kuan. So great question. I'm trying to answer it at the moment because I'm getting questions from my clients about what due diligence I'm going to perform and what safeguards I'm going to put in place relating to this matter. So due diligence essentially is, I guess, my ability to assess the processing organisation or the controlling organisation's ability to implement GDPR and the standard contractual clauses. The SCCs give me some level of legal accountability. Sure, I can sue them later. But are they actually able to implement technical and organisational measures in the spirit of this ruling resulting from the Schrems II case? I think companies both small and large are probably struggling with this equally. I imagine large companies have more resources to think about it and come up with opinions, but ultimately it really isn't very clear how this due diligence would work. And Kuan talked about risk assessment. So when I think about risk, the first thing I think about is likelihood. So is it likely that the intelligence services would want to access the data that I'm controlling or processing on behalf of European data subjects? And instinctively, initially my thought was no. But then when you read the background to the ruling, a lot of this is about proportionality. So it is the fact that US intelligence services or other third countries are using disproportionate amounts of data collection to support their activities that's part of the problem. So I don't think I can really think about likelihood. When I think about technical and organizational measures, that's something that's great in terms of security. In terms of in a normal context, I want someone to make sure the data is secure. So, and I want to make sure they keep it private. So I can look at, do they have a data protection officer? Do they have a process? Has that process been audited by a third party? And I look at this stuff for things like AWS and Microsoft's cloud services. It's all irrelevant in this context because the organization, if the intelligence services walk in and lawfully tell them that they have to do a thing, then all those technical and organizational measures are worth nothing. So, and I think we'll come back to talking about what some of these additional safeguards might be. But how we do this risk assessment and due diligence is an enigma wrapped in a mystery at the moment. And I think it's really important to understand this isn't about storing data in the US or another third country. This is about control. And it might be good if you expand a little bit more on the extraterritorial nature of US law.
Yes, it's not just US law, but lots of countries which are increasingly trying to expand their reach extraterritorially. So, for example, the GDPR itself is extraterritorial. And of course, if you're a US company or if you're an EU company operating in the US, you can be subject to a legally binding order to bring data back in to the US. And what can you do if you're doing business there? They might say, well, if you want to do business here, you've got to do this, otherwise you can't. So it's not just US companies, but EU companies doing business in the US or any other country that could be subject to a legal requirement to bring back data from somewhere else. And so if they do that, and that is a breach of the transfer restriction under the GDPR, then they're caught between a rock and a hard place, because you obey the law of one country and you breach the law of another. So, it's an impossible situation for organizations that operate globally to be in.
So if we look at the tools we've used to organize this webinar, from Eventbrite to Zoom to Outlook and Office 365, I don't think any of those we can apply safeguards to. I know if I go to, say, the Microsoft terms and conditions, I will see that my data resides in Europe, which is great. It didn't a few years ago. But the fact that Microsoft is a US company means it's not relevant where my data is stored.
So is that an opportunity for us to just come on and talk a little bit about the standard contractual clauses implications then? Actually, Adam, perhaps you can carry on with that thought.
Well, I can talk about that inadequacy. As I say, they don't mean anything if I can't put additional safeguards in place. So, and perhaps some of my legal colleagues on the panel would clarify that for me, but I don't see any way that I can use encryption to comply with these requirements. Yes, there are ways to process encrypted data, homomorphic encryption, trusted execution environments. These exist. Those aren't the use cases that most businesses are using. When I use things, I'm using storage. So if, say, I have a recruitment system in the cloud, a SaaS system, okay? A SaaS system can't process data unless it understands it and knows what it is. Maybe I take infrastructure. So I can fire up a server in Amazon or Azure, and I can encrypt it. And by default, it will use a key that's obtained by the cloud provider, and they'll give me reams of documentation about how they keep that key in a locked room and no one can access it, etc. That doesn't mean they haven't got access to it. If it is used in the cloud environment, then the provider can access it. The only way I could have encrypted data that is stored in the cloud that the provider doesn't have access to is if every time that data is accessed, it's downloaded to my computer and decrypted locally on my computer. That's the only way that I'm aware of that encryption can help support data storage in the cloud.
But that's why, hopefully, developments like trusted execution environments, confidential computing, I know it's all early stages, homomorphic encryption, all early stages, but I think the resources need to be put into making sure those are workable and cost effective rather than lots of paper, because going back to the due diligence point, as I've mentioned earlier, it's just impossible to assess the laws and surveillance laws of every single country where you might have data. So, what can organizations do? SCCs are virtually the only method that they can use, and at least the court has said that's still valid. So you've got to plaster everything with SCCs if you can. Encryption, at least it's something. It's better than nothing, and particularly in transit, and as well as at rest. And then, if you can, maybe have some additional contractual terms, like saying you will only hand, the recipient will only hand data over when it's legally binding order, and not just because they've been asked to and they want to cooperate, for example. But yeah, it is a very difficult task.
So we journos like these sort of open-ended future questions. Kuan, I'm going to put this one to you about what is next for Privacy Shield. I like your little phrase in your introduction. Maybe we should just call it Privacy Elastoplast and move on from there. How do you think these things might develop over the next few months?
Well, at least they're working on it because they know it is important to try and have something in place to validate transfers, given the enormous numbers of transfers between the EU and the US every day or every second. So they're working on it, but it's going to take time before they have something in place. And then, of course, that's likely to be challenged again, unless the US changes their surveillance laws, which is, to be honest, extremely unlikely. So, you know, that's why I said it's kind of a whack-a-mole, might be a kind of whack-a-mole situation there.
Lovely. Now, we've had a few questions come in. Please keep them coming in, folks. We'll come on to them in a few minutes. Just like to ask the panel, first of all, about what benefits there might be in just raising this a little bit more in the public mind, because BCS wanting to make IT good for society, this demonstrates a real Maximilian Schrems himself and the approach he's taking, but also the seriousness of this legislation. It shows that is actually being done, but it's not that widely known, is there? What more can we do?
It's barely known at all, and from every business in the UK that deals with the computers is probably using some form of US controlled cloud service, and 90% of small businesses won't be aware of this issue. They won't be aware that a decision has been made with no grace period, and they're already in breach, essentially, of this decision without having done all these safeguarding steps that we can't quite identify. So businesses and lots of people that work in small businesses and have responsibility for things like this just aren't aware of it. It's started to get into the public sphere. The articles about Facebook, in particular, in The Guardian, but there's very little press coverage on this issue, and I think BCS has a large place to play here in making sure its membership is aware of these issues.
Good. Chiara, can I bring you in there?
Yes, I think I couldn't agree more. I think that there's been almost a culpable silence on the part of the mainstream press about this. Partly us privacy geeks and lawyers are not great communicators, so partly it's our fault. But to see that there is almost a perception of this as a niche legal issue, it's very damaging. This should be front page on business press, on EFT, on The Economist, and it's not there. We're not there yet. You cannot have trade unless you have data flowing. So you mess up with data flows, you mess up with trade flows. It's as simple as that. But there is also a sort of almost a decision not to discuss anything that is tainted by politics, and because the issues of sort of relationship between not only the EU and the US, but also now between the EU and the UK have a strong political overtone, there's a sense that nobody should go there. And that's wrong. That's wrong because data is becoming a politicized issue, but that doesn't mean you should know about it and you shouldn't have a plan to deal with it. So in essence, understanding the lie of the land, understanding the dynamics, the geopolitical dynamics of negotiations, of trade deals, etc., becomes part of your job as even of security agencies. Access to data becomes central core part of your competence as a data protection officer and as a person who needs to design the architecture flows, the data flows of your organization. So it's sort of, sorry guys, but it's now become part of your job. But yes, benefits on a number of levels. It would benefit to have this data flows central to any future sort of trade agreement or talks agreement between countries. The standard position by the EU until now was this is a separate issue to trade. You can't discuss data protection, which is a human rights issue, alongside trade agreements, which are totally different. So we will not even go there. This has mollified recently. I understand that Barnier took that back. So I'm happy to see movement in that area. But up until a few weeks ago, the position was we'll only look at the UK adequacy, for example, after the UK has submitted its homework at the end of December, after the end of December. So now I'm very happy that that's moved on, but there needs to be a lot more awareness of the wider impact of agreements or lack of agreements on data flows. So I think, yes, absolutely. I want to see front page, over.
Kuan, I saw you gesturing.
Oh, I was gesturing because, of course, the European Commission did say in its 2-year report on the GDPR that it was now going to include data protection as part of the trade talks. And I agree with you, Chiara, it should be, because, of course, if you don't include it, then you can't say we want you to have good data protection before we want to trade with you. So I think that's a good thing. But yeah, it is a very politicized issue, as you say, but data is vital to trade, and we need to have a way to allow data flows properly. I'm not sure we're there. If I might jump ahead, I saw one of the questions about security. Shouldn't the focus be on security, not physical location, but how do you protect and secure personal data wherever it is, rather than focusing on physical location? And you know, that's the main thrust of my book.
Yeah.
And I think the debate needs to move to encryption. And if everybody everywhere encrypts everything, it'll make it a lot harder for, I know that if you're targeted by an intelligence agency, then they can probably get your data. But if everybody everywhere encrypts everything, then it's going to be much harder.
Yes. We'll come back to you on that one in a moment, Kuan, if that's okay. We have one more question that we wanted to put to the panel. I don't know who'd like to pick this one up, about the principles behind the US and EU differences in terms of privacy, or is it just about a worry about surveillance? As you know, we are non-partisan on party political issues, but this is about the underlying principles, isn't it? So is there an incompatibility between the US and EU privacy principles? Chiara, is that one you'd like to take up?
I would, but probably not as a first attempt. I would like to have either Adam or Kuan sort of have a go at this, because I do have strong views and I don't think they're mainstream. So I'll.
That's okay. We're open to all views. Kuan, is that one you'd like to pick up?
Well, there are differences, of course, between the EU and the US, because in the US, there is no single system for privacy law. It's very much patchwork. That doesn't necessarily mean that US privacy law is bad. I mean, before the GDPR, there were much bigger fines in the US for breach of privacy than over here, for example, by the Federal Trade Commission. So, and as regards surveillance laws, which I know Chiara has views quite strongly about, I think it is true to say that surveillance laws in the US have a certain approach, but then there are also surveillance laws which go quite deep in the EU and the UK. And I mean, one of the issues with the EU, I don't know whether the word's an issue, but one of the underlying points, I suppose, is that national security is up to individual member states. The EU has no competence to regulate national security. Therefore, if you're in the club, if you're part of the EU, you can almost, I say almost, do anything you like in terms of national security, because the EU cannot dictate what you do or don't do. I mean, the court has to some extent tried to say that anti-terrorism, laws, it's serious crime, and therefore you can't have bulk surveillance, for example, for serious crime, and kind of indirectly get it that way. But it does, and I know, Chiara, you've got views on hypocrisy, but it does remain true. If you're in the club, you kind of okay on national security, you can do a lot of things. If you're outside the club, as the UK will be after Brexit, then the EU is going to say, well, you're doing collecting a lot of data for national security, and that's not good. That's the way it works with the EU.
I think there's also another aspect to this in that the US and the UK have form on these issues of bulk data collection to a larger degree than other European countries. So Snowden revelations was many years ago now, and we saw that not only, well, I think as well as seeing the FISA regulations in the US and seeing that the US can legally do some of this stuff. In the UK, there's been things that the government has done around bulk collection that weren't legal. So the issue really for me is about rule of law in the context of national security, rather than a conflict between the privacy principles between the EU and the US and the UK.
And if I may chip in quickly before Chiara, when you talk about the rule of law and bulk surveillance, one controversial issue is, could you actually say that bulk surveillance is okay provided there is sufficient oversight and therefore that complies with the rule of law? And you just destroy the data after a certain time, you make sure, there's independent oversight, etc. So, you can look at it in different ways. You could say, no, you can't have bulk surveillance, or you can say, yes, you can if you have proper oversight, and that still comply with the rule of law. It's just difficult to know where you kind of draw the line.
Chiara.
Okay, right. I'll keep it short, but I know it's a minority position. It's totally non-mainstream. So I've given it a name. I've called it the Schrems 22 position. So what does that mean? Businesses are put in a catch-22 by Schrems, hence Schrems 22. And the catch-22 is that they are asked to assess whether a third country's laws offering security services access to, or regulating access to personal data for security purposes, are proportionate and limited to what's strictly necessary in a democratic society. Now, let's get real, okay? On paper, that's what every controller, every single business selling wine, selling cheese, selling tea should be able to do. This is an impossible. Now, I also strongly feel that the interpretation of Schrems II given by Maximilian Schremm is not the official interpretation of Schrems II. We can all have our own, and I have my own. I do not believe that this court is seriously mandated the impossible. I believe that courts, I also don't believe that this court made a political decision. I think this court made a decision that applied the law to the letter in order to explode or bring to the fore how paradoxical the situation is. The situation that you just mentioned, Juan, which is that we are, by law or the Gdpr, or our framework, a legal framework for data protection, asks us to investigate third countries' security guarantees, but not the European ones. So I think by applying the letter of the law in such a draconian manner, the court is pushing to the mainstream conversation, to the fore, the so-called security issue, the security agencies question. We should all know more about what the security agencies are accessing, including European countries. And I think the court has form in that. To the extent that they can, they're creating a higher threshold. They're creating barriers to what the security agencies have, but also the various is taken to the fore, bringing to the fore the very paradoxical situation that part of the European countries, part of European member countries are NATO members, and so is the US. So as NATO members, US and its allies have to share personal data and have to cooperate in foiling terrorist attacks, in foiling threats to national security. NATO has the power to trigger Article 5. A cyber attack on one member is a cyber attack on the alliance, so the allies have to step in and help. There is a NATO understanding that member states are asked to offer their cyber weapons or cyber attack capabilities. So can we get real, please? Can we decide what we want to do? If we do rely on these alliances, but the security alliance of NATO is sort of at an angle with the membership of the European Union, can we please have a conversation between the European Union sort of competencies. I know it doesn't at present have competence on security, but can we please have a rational conversation and let's involve our NATO allies in the conversation. And I know that's not a mainstream view, but I think it's the only one that makes sense for me of this judgment, that doesn't turn it into a utopia or a utopia riding on hypocrisy or anything else. I really think this needs to be had, and it needs to be public conversation.
Thank you, Chiara. That's very interesting. So I think we've got the sense there from your comments and indeed the previous ones of the complexity of some of these issues. So our debate's gone on a little bit longer than we normally do, to be honest, but that's okay. There's been some fascinating stuff raised. So we've got some questions coming. I'm going to put some of these to the panel. We're not going to get to all of them. I'd just like to start with this one. Most businesses I work with rely on the guidance issued from the ICO. Is this sufficient for interpreting and applying Schrems II, or are we being naive? That's from Richard. Thank you. Who'd like to take that one? That's a bit of a minefield. Thank you.
Which guidance, though? The webpage from the ICO that deals with the Schrems II issue says they're still trying to figure it out, and for now you should take stock of your data transfers and they'll get back to you.
Okay, well, I think that's a fair question, isn't it? Okay, thank you. Here's a question then from Edward.
Sorry, can I just add to that? Of course, you should always look. Of course, you should always look at the guidance of the destination country. So if you send boxes of tea to Berlin, you should always look at the data protection authorities of Berlin. So it's, you know, look beyond the ICO to the extent that your trade requires you to do so, that your data flows require you to do so.
Thank you. Edward Bedell makes this comment: is the best way forward on this issue to use EU-based software as a service, i.e. pull back from the US, or to insist on location of data in the EU? Adam.
It would be a very reasonable thing to do at the moment, given the risks around the adequacy decision and the risk that safeguards won't be outlined by the regulators as sufficient. We could be looking at the great data schism of 2020.
Okay, thank you. Juan.
I just want to add something to that. One of the blog posts at the very end of my slides discusses at great length this issue about, you know, should we just bring everything back? And of course, the problem is that even if you keep data in the EU, there might have to be remote access to from outside for support or for other reasons. Optically, if you are a SaaS provider, you can tell your customers, yeah, everything's hosted just in the EU. And yeah, there might be some remote access for support, but you know, it's minimal, and we're gonna make sure that that's as little as possible. But hey, it's physically hosted here. Now, that comforts people. It doesn't mean that it's necessarily the right approach legally or technically, but you know, optically it is better to have data in the EU. But I just don't think that that is the ultimate answer, really.
Okay. Now, actually, while we're talking to you, Juan, there's a little comment here from Simon Lawrence. Could you, I think this is in your presentation, could you elaborate on the comment that simply viewing data hosted in a cloud application from the US counts as a transfer? Yeah,
absolutely. So if you've got data that's physically stored in the EEA, but a support person from the US has a look at it, then that's considered, even though it's temporary, it's not persistent storage in the US, that's a transfer.
Okay.
Very broad.
Thank you. Tony Proctor makes an interesting point here. Should legislation move away from physical location and focus more on assuming untrusted networks and storage? Adam's nodding. Adam.
I mean, yes, absolutely. I mean, that's I think what we're saying here is that you can't trust something through procedures, adherence to standards, cybersecurity, accountability, even if it's legal.
I always, the example I always use in terms of location is, look, what would you rather, and you're all mostly technical people, I think, on this call, what would you rather have? Would you like to have your personal data in the EU on an open server, or would you rather have it in the US encrypted?
Okay.
And, you know, location is not everything, it's security and access that matters, not physical location. And the law is very 20th century in this regard.
Okay. Well, yes, that figures, doesn't it? We've had an anonymous comment in here. I'm going to read this as is because it made me smile, and someone can take this as they see fit. Stop making it a legal issue. Tell the public how this impacts them. If I give data to my gym, what, if any, are the risks to me? Why should I ask them where they keep my information? Do I care? And as the gym owner, what are the risks to my business? If lawyers are from Mars and geeks are from Venus, people are from Earth. Which is a nice thought, but who would like to pick that one up? Chiara.
Yes, I think you should always consider whether or not you could be stopped, you could be asked to stop processing data, which means you can't use data. The fines are real, so the risks to you are real. You may believe that the UK Supervisory Authority, the ICO, is not likely to enforce the judgment, is likely to wait its time out to Brexit. You're entitled to thinking that, but call it a risk, call it for what it is. The risk is fines, and the ultimate risk is that you may be asked to stop using personal data, and you can't trade, you can't do business unless you use data.
Yeah, thank you.
And just to add, of course, I mean, it is a legal issue in the sense that law, one of the purposes of the law is to protect people's rights. And one of the requirements of the GDPR, you were saying, tell the public how this impacts them, what are the risks to them. Of course, one of the requirements is that there's a privacy notice given to individuals to tell them what's supposed to be happening with their data. So,
lovely.
in a sense, it is.
I'm going to ask one more question at the end here. So Gilbert Hill's just sent this one, a little bit of a hand grenade with a pin out, perhaps. What is the panel's opinion on the state of preparedness of the UK government to life with data post-Brexit? How can they get tools in the hands of SMEs to manage this new risk?
I can answer as a small business owner, I'm unprepared. If we don't get, I have staff in the EU and in the UK, and we have people in the UK that view data about employees. Those staff, if we don't get an adequacy decision, would presumably have to be moved to the EU. And I'm completely unprepared to do that by the end of December.
Or you put in lots of SECs in place, because that's all you can do.
Back to the sticking plaster approach, I think.
Yeah. I mean, but you know, it's kind of like I said, it's literally papering over the cracks. You know, just sign lots and lots of contracts between, or a single contract that incorporates everything between all your relevant companies to allow it. Because what else can you do? You know, it's a very difficult position, and yeah, that's you know, derogations are very difficult to rely on. So effectively, everybody's just got to be signing lots and lots of SCCs and then waiting for the guidance on what supplementary measures have to be put in place from the regulators.
Yeah.
It's very hard not to be judgmental and factual about lack of preparedness. How do you measure lack of preparedness? You know, what counts as open and transparent communication about this issue? So I'll refrain from saying has the government done enough? Is communication sufficient? I'd say that if there's one message that BCS wants to get out, is that it becomes your job. You may have thought up to now that you're an IT guy, that your job is in the server room or in the data room, and that's it. No, it becomes your job to understand also, among other things, how lack of communication is part of this geopolitical game. In any way, minimizing the problem is part of smoothing, you know, what could be a very, very rough road, and take no prisoners. Just go ahead, map your data, understand what risks to have. Use all options. You have legal options, as Juan has said, probably they're papering over the cracks, but that's one option. You have encryption as a technical option, and then you have business options. Don't forget that if a country is not really critical to your turnover, well, just ditch it. You know, it's such a big concern, and you should put it in the risk register. It's such a big risk that if you're not sure about a country you're doing business with, and you only have a handful of clients there that really make no impact to your bottom line, well, just that's a business decision. You can drop that market. So so really mapping your first of all, mapping your business. Where do you get most of your business? How much data underpins that trade, that business with that country? Is this country on the, I've published the CNAIL map, I've published a little advisory note for BCS, and prominent in that was using the map that the French data protection authorities have produced. It's a brilliant interactive map. You know instantly, visually, which countries are considered third countries, so which countries have restricted data transfers. Map your business flows against that map of data flows and restrictions. If you don't do that, you don't know where you stand. And then make a business call if the money that you have to pay to people like Kuan to do the standard contractual clauses is worth the money you get from that country. So, you have to escalate this to the business and the board, because it's not just a technical decision and it's not just a legal issue.
And could I just add on the general front, remember, we still have the GDPR and the Data Protection Act, which implements effectively the GDPR. So even after Brexit, UK businesses still have to comply with the GDPR internally. Now, the UK may diverge eventually, but if it diverges too much, then that's a risk for adequacy declaration on the UK. So there's the issue of complying with the GDPR, and there's also the issue of transfers. And they're separate but related.
Well, can I say thank you very much to the panel. Your comments have been really interesting. Thank you for your scene-setting presentation as well, Kuan, and Chiara and Adam, your comments as well. We answered a number of those questions, at least in a very brief way. We are going to bring this webinar to a close in a moment or two, just to say thanks to everyone that attended, everyone that put questions in, especially our panel, and just to say that we will have further webinars on this subject, and maybe run specifically by the BCS legal specialist group. Certainly here we want to do a few more as well to follow up, because obviously this is a developing situation. So we really appreciate the input. Chiara, Adam, Kuan, thank you very much indeed. And we will say cheerio. If you'd like the presentation, please email me, editor@bcs.org, and look out for the recording of this on our YouTube channel.